Good afternoon, everyone. My name is Lindsay Disalvo, and I want to welcome you all to Occupational Carey's presentation webinar today on delaying retirement, OSHA and L&E implications of America's aging workforce. So my colleague Ashley and I will just take a couple minutes to introduce ourselves initially. As I said, my name is Lindsay Disalvo, and I'm an associate at Occupational Carey in both the firm's OSHA and employment practices. In the employment practice, I represent and advise employers in all aspects of the employer-employee relationship, including wage and hour issues, claims of discrimination, which we'll talk a little bit about today related to the aging workforce, as well as disability-related issues. I also review and revise workplace policies and procedures, which are also very important to the topic we're going to be covering today. And then from the OSHA side, I also represent employers in OSHA inspections and investigations, and advise and counsel employers in responding to complaints from employees, notices from OSHA, as well as OSHA citations. And I will turn it over to Ashley to introduce herself.
Good afternoon, everyone. As Lindsay said, I'm Ashley Mitchell, and I also am an associate at Occupational and Carey. I work in both the OSHA Workplace Safety Practice Group as well as the Labor Employment Group. And essentially, I provide advice and guidance on responding to workplace safety complaints and OSHA citations. I represent and advise my clients in a broad range of employment issues, including wage and hour disputes, which, as Lindsay mentioned, we'll talk about later, Title VII discrimination claims, and compliance with the Americans with Disabilities Act, which we'll definitely cover again later today. I also counsel employers on workplace policies and procedures, harassment training, and employee handbooks.
So this slide just shows our agenda for today, the main things that we're going to try to go over in the hour that we have. First, we're going to spend a little bit of time just reviewing this issue overall, looking at some findings and statistics to kind of show why this is an important and significant issue. Then I will talk about OSHA and the aging workforce, some of the issues that we see arising in the OSHA context relating to the aging workforce. And then we'll pass it over to Ashley to talk about employment and labor issues related to the aging workforce, like issues that arise under the Americans with Disabilities Act and the Age Discrimination and Employment Act. So there is a Senate Special Committee on Aging, and they put out some really interesting information about the aging workforce and issues surrounding the aging workforce. And this slide shows some of the significant findings from their analysis of this issue. So the first is that the number of older workers is growing at a rate that outpaces the overall growth of the labor force. Interestingly, in 2000, about 12.5% of those over 65 were still working, but by 2016, that amount had actually increased to 18.6%. And even more interestingly, the analysis that they did showed that the labor force as a whole is projected to grow by an average of about 0.6% per year between 2016 and 2026, but that number is significantly greater for workers ages 65 to 74. It's projected that that group of workers will grow by 4.2% annually, and then the number of workers ages 75 and above will grow by about 6.7% annually. So we're going to continue to see a significant amount of the workforce that is above the age of 65 and working for a much longer period of time. They also found that fewer older workers are transitioning directly from full-time work to full-time retirement. So that had been kind of the standard in the past. But now many workers are transitioning to part-time positions So still staying in the workplace in some capacity, and only either partially retiring or maybe moving to a more like a self-employed position, but continuing to stay in the workforce. The committee also found that, there are a lot of challenges that make it more difficult for older workers to thrive in the workplace. Those challenges included age discrimination, having inadequate training opportunities catered to that particular demographic, continuing to work while they're also having to manage health conditions and disabilities, which is not generally an issue among the younger workforce, and then also having to balance caregiving responsibilities with being a part of the workforce and working on a day-to-day basis. And then many older workers are, and I'm sure a lot of us are aware of this, but many are struggling to prepare financially for retirement. So that is also causing people to stay in the workforce much longer. Additionally, work has been linked to improved health and well-being. So that is sort of another motivator to continue to stay in the workforce. This next slide shows some statistics related to labor force participation rates. You can see that at the age of 65, at the age of 55, people around the age of 55, about 73.9% of them are still in the workforce. I think a really interesting number to look at is 65, which tended to be the general age of retirement. But now we're seeing that about 40.4% of people around the age of at the age of 65 are still staying in the workforce. They're continuing to work, and you can see that the numbers go down for those older than 65, but still really significant amount. I mean, this shows that at the age of 75, 13.3% of people are still in the workforce. So I think this is a really helpful insight into the amount of people over the age of 55 that are continuing to stay in the workforce. So this next slide shows a breakdown of the type of work that older workers tend to do. You'll see that for those who are remaining in the workforce, most of them are doing management, professional type work, which makes sense. For those that have been in the workforce for longer, moving into management positions is natural. So most of the workforce, the older workforce, are in management professional positions. The next is sales and office work. But you see that this slide shows there are many people in the workforce, older workers, who are still staying in production, transportation, material moving type positions, construction, positions that require, can have more impact on the body, require more movement, lifting, building, more physical activity. And this is significant, particularly in the OSHA context, as it relates to ergonomics and the impact that that can have on older workers who could be more susceptible to injury and musculoskeletal disorders that can occur over time. This next slide shows injury rates for the workforce population based on age. You'll see that younger workers are tending to have greater injury, non-fatal injuries than older workers. But you'll notice that, probably also not surprisingly, the types of injuries that can occur to older workers are more serious. A significant amount of the fatalities that occur are among the older workforce. So that again is important to keep in mind, particularly from an OSHA perspective, and the types of things that employers can do to address these injury-related issues. So why is the workforce aging? There are a bunch of reasons that this is happening. The first is increase in life in life expectancy. With an increase in life expectancy, there are additional expenses that occur. People are having to worry about maintaining their lifestyle for a longer period of time. And because of that, they are motivated to stay in the workforce, earn additional income to make sure that they can take care of themselves and potentially their families for a longer period of time. There is also an increased percentage of older workers that now have defined benefit retirement plans as opposed to defined contribution. This again is a motivator to stay in the workforce longer, because as you're making contributions to your retirement fund, that takes more time than just getting a defined benefit upon retirement. So older workers are motivated to stay in the workforce longer so they can continue to contribute to their retirement fund and have the funds that they need upon retirement to be able to maintain their lifestyle. Another cause of why we have an aging workforce is later age of marriage. People are tending to get married later in life, which also pushes back the timeline often for having kids and some of the other big decisions that people might make related to starting a family. And if you have kids later in life, it would certainly be necessary to work longer to be able to support them, potentially college expenses, things like that, that would then cause a person to be able to work or to have to work longer to be able to afford those things. There is also a decline in the amount and quality of retirement health benefits. So people may not be as motivated to retire now because they could lose their health benefits that they get through, their employer. Employers are not necessarily continuing benefits after retirement, or maybe continuing them in a way that is not conducive to the individual employee. And public benefits may not be sufficient for them. So they're motivated to stay in the workforce longer so they can maintain those health benefits. And then finally, we have seen that Social Security age, when you can get access to your full retirement through Social Security, has increased. And so again, that's another motivator for people to stay in the workforce longer, because they're not going to get their full retirement benefit as early. We also believe that there is an association with the aging workforce because of the recession that we saw in 2008 and 2009 that had a substantial financial impact on the country as a whole, and certainly a financial impact on many of the older employees in the workforce. And so to recover from that, to make sure, again, that the funds are available to maintain lifestyle after retirement, people are having to work longer and continue to stay in the workforce. So what about the business impact on employers? There are lots of things to consider here. There are strategies needed to retain older workers. Older workers are often an asset to employers. They have a lot of knowledge of their jobs. They're, well trained in their jobs. And so there is definitely motivation for employers to restructure and make changes to make sure that they're able to retain their older workers. That could include, providing part-time hours, allowing people to work from home who may have caretaker responsibilities or may have some health conditions that, make it easier for them to operate from their home. There's also the issue of knowledge transfer, particularly for employees that you've had in your company for a really long time. They definitely have an intellectual capital that is really important. They know the processes and procedures. They have a lot of knowledge of the business itself and how it works. And so employers should think about that and how they can set up the work environment to make sure that that intellectual capital is transferred to the younger workforce that might come up and take these employees' places once they do decide to retire. An older workforce also has unique economic and social responsibilities. We already talked about, potentially health-related issues or caretaker responsibilities. And these impact, the way they're able to perform their job and what they need from their employer. And then again, unique personal health concerns that should be a factor to employer. An older workforce also tends to have higher pay levels. Again, they've been at this for a while, and as a result have moved up, and because of their knowledge, because of their expertise, are being paid at higher levels. And then finally, another important impact of an aging workforce on employers is potential intergenerational conflict. I think this can come up quite often from like a communication perspective. Everyone communicates differently. A younger workforce might be more used to one form of communication than an older workforce. This can also come up in the context of use of technology and what, the different demographics of your workforce are used to. So these are all important things to keep in mind as potential impacts on employers. So this slide kind of shows where we're going to focus most of today. As I said, I will review the Occupational Safety and Health Act and its impacts initially, and then Ashley will go over these other three statutes and how they are impacted and impact an aging workforce. And then finally, before we jump into the OSHA slides, we just kind of want to review real quick, what employers are doing to prepare, and if employers are taking the necessary action to prepare for an aging workforce. There was a survey conducted by SHRM that showed that just over 1/3 of organizations were examining policies and practices to address this demographic change. So that means that 2/3 of organizations have not undergone that examination of their policies and practices. And that is a really important step to make sure that employers are effectively accommodating an aging workforce. The survey also showed that an additional 20% of organizations that were surveyed had examined their workforce and determined that no changes in policies and practices were necessary. I think that an effective review of policies and practices would likely lead to some changes, and we'll talk about that a little bit in the OSHA context as well as in the employment context. What types of things employers can look for, how they can examine their work environment and their practices to ensure that they are taking steps necessary to accommodate their aging workforce. So turning to OSHA and the aging workforce, I think an obvious place to start in the OSHA context is injury data. And what are we seeing as a result of our workforce aging? Older workers are generally less likely to be injured at work. I think we saw that a little bit in the prior slide that we looked at of non-fatal and fatal injuries. And that tends to happen because, again, they have been in their positions for a while. They've learned lessons about how to operate safely, what they need to do on a day-to-day basis to avoid injury. And, we also see this happening because, again, those older workers are moving off of the front lines. I mean, a lot of occupational injuries that occur happen to, those working right on the assembly line, performing more physical tasks, performing maintenance types activities. And because older workers have been in this role for longer, they've moved on to a supervisory or management position where they're not exposed in the same way to sources of injury. However, you do see from the chart shown here that the impact of an injury can be more significant and does tend to be more significant for an older worker. You see from this slide that workers that are 16 to 19 years of age are averaging about 5 days away from work related to an injury that results in days away from work. And those injuries do tend to be more significant, whereas workers 55 to 64 and 65 years and older are averaging 14 days away from work related to similar types of injuries. And, I think a good example of this is, if they are doing more manual labor, the strain that a younger worker may experience, they can tend to recover more quickly because they don't have the physical changes and impacts that an older worker would have. Whereas, doing the same activity that causes a strain in an older worker, it can definitely be a more severe injury, which would lead to the need to take additional days away from work. So this type of injury data is really important for employers to be aware of in, again, accommodating their older workers and figuring out, what changes might need to be made in their own workplaces to prevent against these types of injuries. The biggest issue that we see related to OSHA and OSHA enforcement in the context of an aging workforce is ergonomics. And generally, ergonomics is the science of fitting workplace conditions and job demands to the capabilities of the working population. In the OSHA context, OSHA ergonomics is assessing work-related factors that may pose a risk of musculoskeletal disorders, and based on that assessment, making recommendations as to how to alleviate those types of risks to employees. So when OSHA talks about ergonomics, it's the employer identifying ergonomic risks and coming up with solutions to address those risks. Musculoskeletal disorders are a significant issue among older workers, and they are injuries to muscles, tendons, ligaments, cartilage, or spinal discs or nerves that are not caused by a specific incident like a slip and fall or a motor vehicle accident, but occur slowly over time. They're usually caused by repetitive motion activities from a perspective of those engaged in more manual type labor. This could be, having to lift things often, having to pull the lever of a machine constantly, having to bend over a lot to perform maintenance work. These can all lead to musculoskeletal issues. And then, in the context of an office worker, sitting at a desk all day, typing, using a mouse, those can tend to lead to musculoskeletal disorders like carpal tunnel syndrome. And you'll see there that we have a list of common musculoskeletal disorders, rotator cuff injuries, muscle strains and back injuries, like the example that I gave, having to bend over a lot to perform maintenance or repairs. That could certainly lead to musculoskeletal disorders in the back, tendinitis, carpal tunnel syndrome, and trigger finger. These are the types of things that tend to arise in an aging workforce. And then ergonomics is a big deal, particularly among an aging workforce, because of just the natural physical, musculoskeletal, and cognitive changes that occur as humans age. This slide shows some of the changes that tend to occur that can lead to greater susceptibility to ergonomic injury. And then if those injuries occur, they certainly tend to be more significant among an older population. We already talked about, the worker who could experience a musculoskeletal disorder with their back through a degenerative disc condition. That degeneration can just naturally occur over time. And then if they, in the workplace, bend over a lot, have to crouch to get under machines or something like that, that can certainly speed up the process or make the degeneration more significant. Arthritis is another thing that commonly occurs naturally in older people and can certainly be impacted by the types of tasks that the person must perform in the workplace. And because of some of the physiological or cognitive changes workers experience, they can be more susceptible to other types of injuries as well. For example, reduced balance is a thing that naturally occurs as we age, and reduced balance could cause trip and falls to happen more easily And because of the physical changes and the musculoskeletal changes, the person could experience a more severe injury if a slip and fall were to occur. So OSHA ergonomics enforcement. This slide shows how OSHA has enforced ergonomics over time and the efforts that they've made to try to enforce ergonomics over time. So during the Clinton administration, OSHA did enact an ergonomic standard. That standard was subsequently repealed using the Congressional Review Act. It's been one of the few uses of the Congressional Review Act over the past, many years. And because it was repealed using the Congressional Review Act, it is something that OSHA cannot reintroduce in the same or significantly similar form. So OSHA passing another ergonomic standard is unlikely, but OSHA has done other things to beef up its enforcement efforts and can use the general duty clause to enforce ergonomic issues in the workplace. For example, during the Obama administration, OSHA did propose a musculoskeletal disorder record-keeping rule, and in that rule proposed to add a column to the 300 log that would be specifically for musculoskeletal disorders and require an employer to actually identify injuries as musculoskeletal disorders when they record them, if they have to record them. That rule did not get much traction during the Obama administration, and the Trump administration is on the long-term action list, so not something that OSHA is currently focused on or something that is likely to progress anytime soon. That could change in the new administration, but for now, that's just kind of hanging out there, and there's been no movement on that. But if there is, the impact would be significant for employers. OSHA does a review of injury and illness logs when it does any type of inspection. And if it could more readily and easily identify musculoskeletal disorders, it would be easier to, pull those from the log and assess whether there are certain aspects of the work environment that are leading to those types of issues. And it would also be something that OSHA could point to say, look, employer, you were aware of this ergonomic issue because you had, X amount of employees who experienced a musculoskeletal disorder because of it. And so we're going to use that to support a general duty clause citation. During the Obama administration, there was also a nursing home National Emphasis Program, or NEP. There are no current NEPs or new directives related to ergonomics. But there are still guidance documents out there. During the Obama administration, OSHA did put out some ergonomic guidance documents for different industries. They are classified as guidance documents. They are something that are technically not mandatory, but this is another document that OSHA has relied on in supporting general duty clause citations. OSHA says, we put out this document that identified ergonomic issues in your industry, that identified how to effectively address ergonomic issues in your industry. You did not identify those hazards. You did not adequately address them. And so we're going to use that to serve as our basis to say you were on notice and you didn't take the steps necessary. So, we see this a lot with guidance documents. They're called guidance documents, but they're used as the basis for a citation. So it's important to be aware of those guidance documents because they are still out there on OSHA's website related to certain industries, and I'll review the specific industries. So OSHA and Ergonomics, there are guidelines for certain industries, specifically shipyards, poultry processing, retail grocery stores, nursing homes, and meatpacking plants. It's really important that those industries are aware of those guidelines, familiar with those guidelines, because again, OSHA could go back to those to support a general duty clause violation. In addition, if trade associations or industry organizations are putting out guidance about ergonomic issues, what certain industries should be aware of, how they should address those issues, OSHA could also rely on those types of things to support a general duty clause violation, so it's important to be aware of them. So how to tackle ergonomics in the workplace. I won't go through all of these in detail, but just some steps employers can take. Review and analyze injury and illness records. This is a great source of information on what could potentially be causing musculoskeletal disorders, and especially if you're seeing repeated musculoskeletal disorders of the same type among your workforce, that's probably an area where the employer can step in and make some changes to how a task is performed. Periodic job site reviews, going through the facility, seeing how people are doing certain activities, whether there could be changes to that process or procedure to protect against musculoskeletal disorders. Review OSHA guidelines, we've already talked about that. And I think a really good one too is encouraging employee input, asking employees, what do you think is causing strain to a particular part of your body while you're performing this task? Do you have any ideas for how we could potentially do this differently? And then using those suggestions and incorporating them into how a task is done. And then proactive measures that employers can take to try to tackle ergonomic issues. Again, using those regular facility audits, maybe increasing the number of facility audits to observe how jobs are being performed and whether there can be changes made. Restructuring job duties where you see that there's an individual who might be being impacted by performing certain tasks, reassessing how those tasks are performed and whether they can be shifted to someone else. Performing job safety analyses are a good way to identify and tackle ergonomic issues. And then having wellness programs and stretching programs that proactively work to try to prevent against the development of a musculoskeletal issue. Another OSHA area that is important in the context of an aging workforce is record keeping. There is a geographic presumption in the context of record keeping that if an injury occurs in the work environment, it is work related. But again, some of these types of injuries like musculoskeletal disorders, it's really hard to tell whether it occurred in the work environment. So it's important to do a careful analysis of this. There are also many exceptions to the presumption of work-relatedness, one of which I think is particularly important in this context is signs or symptoms of a non-work-related injury or illness that arise at work. So if the employee has a non-work-related health condition and the symptoms of that condition just happen to arise while they're at work, that's likely not a recordable case as long as the work environment had no impact on the signs or symptoms that occurred, and it's all just the non-work-related injury or illness. And then lastly, there's no eggshell exception. So the concept here is that the employer has to take the employee as they are, again, with the physiological changes that can occur as a worker ages. The injury or the incident that occurs can be more severe just because of those natural changes. And it doesn't matter that it happened to an older employee, and that's why they needed days away from work as opposed to just medical treatment beyond first aid. That you just have to take the worker as they are and the injury as it happens and whatever it results in and record if appropriate and necessary. Some unique record keeping and reporting issues. There is an exception to recording a work restriction related to musculoskeletal disorders in certain instances. It has to meet 3 specific criteria, the first of which is the employee experiences a minor musculoskeletal discomfort. A healthcare professional determines that the employee is fully able to perform all of his or her routine job functions, and the employer assigns a work restriction just for the purpose of preventing a more serious condition. So if all 3 of those elements are met, then a musculoskeletal disorder may not need to be recorded. Work-related cancer and chronic irreversible disease and fractured or cracked bones have to be recorded if they're work-related, even if they don't result in days away from work, work restriction, or medical treatment beyond first aid. These are within a class that OSHA has identified in its standard as automatically recordable if they are work-related. Under the reporting standards, an employer only has to report a fatality or inpatient hospitalization caused by a heart attack if it's work-related. The work-related assessment should still be done in this context. This could be one of those situations where there's a non-work-related condition, the symptoms of which just happen to come up while the employee is in the work environment. So it is important to do that work-related assessment. And then finally, if an inpatient hospitalization occurs just for observation or testing, that is not a recordable or reportable inpatient hospitalization. It might be recordable. You have to do that separate assessment, but it is not reportable if it's just for observation or testing. And then the last main topic we'll just briefly cover here is occupational hearing loss. As you are probably aware, OSHA does have a hearing conservation standard that requires employers to take audiometric readings if employees are exposed to noise levels above a certain designated level. Employers are required to also record significant losses of hearing, also known as standard threshold shifts pursuant to the standard. And employers who have workers who are exposed to noise at certain levels also need to have a hearing conservation program in place. The standard does allow employers to account for natural hearing loss, which may be caused by workplace conditions, but also just by natural aging. So specifically, the standard says that in determining whether a standard threshold shift has occurred, employers are allowed to consider the contribution of aging to the change in hearing by adjusting the most recent audiogram using a calculation that the standard provides. But the important thing to note here is that the standard only goes up to age 60. And obviously, hearing loss continues to occur past the age of 60. So the calculation that OSHA provides might not really pull in the full impact of natural hearing loss in assessing whether workplace hearing loss has occurred and a standard threshold shift has occurred. And then lastly here, what employers should do. We've talked about a lot of these things already, so I won't really spend too much time on this. But you know, it's really important for the employer to embrace the aging workforce and develop policies and procedures with that in mind. And looking at injury and illness records, assessing ergonomic issues are a really good way to do that and to ensure that they're taking steps to accommodate that aging workforce and make sure, you know, that they are putting things in place to avoid potential citations from OSHA related to ergonomics. So I will now pass it over to Ashley to talk about employment-related issues for an aging workforce.
Thanks, Lindsay. So as Lindsay said, we're now going to talk about the labor and employment side of an aging workforce. First, looking at the Age Discrimination and Employment Act of 1967, which we often refer to as the ADEA, which forbids discrimination in any aspect of employment, including hiring, firing, pay, job assignments, promotions, layoffs, training, fringe benefits, and then any other term or condition of employment. And so what this means is it's unlawful to harass a person because of their age. An example being you are not allowed to make offensive marks about a person's age. And so these offensive marks become illegal when it is so frequent or severe that it creates a hostile work environment or it results in an adverse employment action. And so with age discrimination, we have the Older Workers Benefit Protection Act, and it establishes specific requirements for the knowing and voluntary release of ADEA claims, and it guarantees that an employee has every opportunity to make an informed choice about whether or not to sign the waiver. There are 7 factors, which I will cover in the next slide. It is also important to note that an employer cannot attempt to cure a defective waiver by issuing a subsequent letter containing the OWBPA required information that was omitted from the original agreement. Even when a waiver complies with the OWPA's requirements, a waiver of age claims will be invalid and unenforceable if an employer has used fraud, undue influence, or other improper conduct to coerce the employee to sign it, or if it contains a material mistake or omission or misstatement. And so I mentioned that there are 7 requirements, and they are that it must be written in a manner that can be clearly understood. It must specifically refer to rights or claims arising under the ADEA. Number 3, it must advise the employee in writing to consult an attorney. Number 4, must provide the employee at least 21 days to consider the offer. Number 5, must give an employee 7 days to revoke his signature. Number 6, must not include rights and claims that may arise after the date on which the waiver is executed. And then last, but certainly not least, it must be supported by consideration in addition to that which the employee is already entitled. And so there are also additional requirements under the OWBPA, the first being exit incentive programs. These are voluntary. The other employment termination program, which is an involuntary termination, and the employer must provide 45 days to consider waiver. And so when employers decide to reduce their workforce by laying off or terminating a group of employees, they usually do so, or it's been our experience that they usually do so pursuant to 2 types of programs: that exit incentive program, which is the voluntary program, and then other employment termination programs, which is the involuntary program. And so when a waiver is offered to employees in connection with either that exit incentive or other employment termination program, an employer must provide enough information about the factors it's using in making these selections to allow employees who were laid off to determine whether older employees were terminated while younger ones were retained. And so typically an exit incentive program, as mentioned, is voluntary, and it's where an employer offers 2 or more employees, such as older employees or those in specific organizational units or job functions, additional considerations to persuade them to voluntarily resign and sign a waiver. An other employment termination program, that involuntary termination program, generally refers to a program where 2 or more employees are involuntarily terminated and are offered additional consideration in return for their decision to sign the waiver. And so whether the program exists depends on the facts and circumstances of each case. However, the general rule is that a program exists if an employer offers additional consideration or an incentive to leave in exchange for signing a waiver to more than 1 employee. We contrast this with a large employer terminating 5 employees in different units for cause, for example, for performance, over the course of several days or months. You know, that is unlikely to rise to the level of an existing program. In both the exit incentive and other termination programs, the employer determines the terms of the severance agreement, which typically are non-negotiable. And so before we wrap up our discussion on the ADEA, it's important to talk about that in the context of what's going on right now in the world as it relates to COVID-19. And so if you will recall, the ADEA prohibits age discrimination. And so it's against all employees over the age of 40. And what that means is the employer may not involuntarily exclude older workers based on age-related risk or more severe illness from COVID-19. So an employer can't say, hey, employee over 40, you can only telework for your own good, because that would violate the ADEA. Instead, an employer can invite employees to express concern and the ways that the employer can help and start a dialogue. And I want to place emphasis on that invitation piece of that conversation. The ADEA does allow more favorable treatment of older workers based on age. So employers may choose to offer flexibility to older employees based on age, even if they deny it to younger employees. But there ultimately is no ADEA right to accommodation based on age or age-related risk as they relate to COVID-19. And so older workers may, of course, request an ADA accommodation for medical conditions, which we will get into when we discuss the FMLA. It's important that employers remember that there's no disparate treatment based on older age if offering flexibility to comparable workers. So if the employer decides to be flexible with certain workers, for example, workers who are parents of young kids, and then another group of employees request that same flexibility, you must also be flexible with them. You must help all your workers and cannot say, you know, I will not help an employee based solely on their age. And I would also like to note that there are some states that have enacted emergency temporary standards that encourage telework wherever possible. And so with that being said, we are moving on to disability discrimination, which is covered by the Americans with Disabilities Act. Title I of the ADA prohibits private employers from discriminating against qualified individuals with disabilities in job application procedures, hiring, firing, advancement, compensation, job training, and other terms and conditions of employment. It also prohibits retaliation on the basis of disability. And so to be protected by the ADA, an employee must have a disability or have a relationship or association with an individual with a disability. And an individual with a disability is defined by the ADA as a person who has a physical or mental impairment that substantially limits one or more major life activities. And a person who has a history or record of such impairment, or a person who is perceived by others as having such an impairment. And the ADA requires the employer to provide a reasonable accommodation so that the essential job functions may be performed. And so here we see that the ADA does not specifically list all impairments that are considered disabilities. So a physical or mental impairment that substantially limits a major life activity, or a person with a record of such impairment, or a person who is perceived by others as having such impairment, is pretty broad, but it's not intended to cover temporary medical conditions. And it's important to note that disabled employees are not always eligible for FMLA leave. As defined, a serious health condition and a disability are not the same thing, and so they are not mutually exclusive. Most disabilities, however, will qualify as a serious health condition under the FMLA, but not all serious health conditions will qualify as a disability. And so what we've seen is, more often than not, courts are no longer issuing determinative rulings finding that the employee did not have a disability. And so turning to the physical or mental impairments and conditions consistently qualifying as a disability, as far as the physical or mental impairment, severe stress-related symptoms of IBS, ADD, PTSD, severe anxiety, and disabilities of that, or stress and symptoms of those types of stressors may all be considered disabilities. However, there are some limits on what is or is not considered a disability under the ADA. And so here we see an example such as a neurological, musculoskeletal, which Lindsay covered, and the OSHA piece, special sense organs, respiratory, including speech organs, cardiovascular, digestive, and so on, are listed as physical impairment because they're affecting the loss of one or more body systems. And so here on this slide, we are just going deeper into the term substantially limits, which means requires a lower degree of functional limitation and is construed broadly. So the courts look at this broadly in favor of expansive coverage. The determination of an impairment that substantially limits a major life activity is made without regard to ameliorative effects or mitigating measures. And so, again, leaning more on that broad, expansive coverage. However, impairments that are episodic or in remission may also be considered a disability. And so here on this slide, we see some examples of major life activity. I'll just point out some of the key ones: seeing, hearing, eating, sleeping, walking, standing, reaching, and lifting, which Lindsay covered in the OSHA portion of the presentation. So what happens when an older worker requests, or what is required of an employer when an older worker requests a reasonable accommodation? First, it's important to know that the worker coming to the employer does not have to say off bat that they are requesting a reasonable accommodation when requesting help. The next thing to note is that when that employee takes that initial step to ask the employer for help, it is the job of the employer to assume that the worker likely qualifies as disabled, and so that they do not immediately reject the request for reasonable accommodations. Instead, employers must engage in an interactive process about the reasonable accommodation. And that looks like asking for details on how the accommodation would work in the employer's workplace, looking for reasonable alternatives to solutions, and just really having that conversation with the employee about what would work best for them and how that could play out in the workplace. And it's important that the employer documents all of these conversations in case it comes up at a later date. And the employer also has the right to request documentary verification from the employee. And so what about telecommuting as a reasonable accommodation? And so telecommuting may be a reasonable accommodation under the ADA, except where regular attendance is an essential function of the job. And we've seen this play out in court, where it may, in fact, be a reasonable accommodation as long as being physically present in the workplace for jobs that Lindsay would have covered, like construction or factory work, is not, an essential function of the job. And so we are other options available to an employee requesting an accommodation may be leave requirements. And so ultimately, the employer must provide a reasonable accommodation for a qualified disabled employee unless that accommodation would place an undue burden on the employer. And so that just means that they were unable to find a workaround for the employee to provide the essential functions of their job. And so the next potential option is a leave of absence if that leave of absence would allow the employee to return to work and perform their essential job functions. And so the employer in that instance must give the same benefits to both disabled and non-disabled employees on leave status. The employer, however, does not have to continue to pay for health insurance if the employee is not covered by FMLA. Looking at the type of medical certifications an employer may request. So generally, if you comply with FMLA requirements on these medical certifications, you will also comply with the ADA limits. And so with a medical exam, whether a procedure is a medical examination under the ADA is determined by considering factors such as whether the task involves the use of medical equipment, whether it's invasive, whether it's designed to reveal the existence of a physical or mental impairment, and whether it is given or interpreted by a medical professional. And so the standard for in-career exam during employment, generally a disability-related injury or medical exam of an employee is job-related and therefore consistent with the business necessity when an employer has a reasonable belief based on objective evidence that an employee's ability to perform those essential duties of the job will be impaired by a medical condition, or that that employee will pose a direct threat due to the medical condition. And so that begs the question, when can an employer ask about disability? And there are different standards for that depending on the employee's status. So an employer may ask about disability-related questions in a health risk assessment questionnaire as part of the wellness program, but only if answering those questions is voluntary. And so we see also that an employer may ask a job applicant about the existence of illness or disability. For example, asking an individual if his immune system is compromised is a disability-related inquiry because a weak or compromised immune system can be closely associated with certain conditions. By contrast, an inquiry is not disability-related if it is not likely to elicit information about a disability, and so that's something an employer could not ask. For example, asking an individual about symptoms of a cold or the seasonal flu is not likely to elicit information about a disability. And so as employers are asking these questions and collecting this information, it is important that they remember that there are confidentiality obligations that prohibit an employer from disclosing medical information. The EEOC does note that an employer can explain to others that are acting for legitimate, that the employer is acting for legitimate business reasons or in compliance with the federal law, but ultimately there must be confidentiality of whatever the worker is sharing with the employer. And so we did speak briefly about leave of absence as a potential reasonable accommodation. And so if that is given as a reasonable accommodation, there are greater reinstatement rights under the ADA than the FMLA, which means an employer must reinstate the employee to their original position, and emphasis on that original position, except or unless they can demonstrate keeping the position open will cause undue hardship. And so if that is in fact the case, and then the employee cannot receive the same job, the employer must reassign the employee to any vacant position that they are qualified for. And so we spent a lot of time talking about reasonable accommodations. What might that look like in light of the current pandemic? And so what the EEOC has given us some guidance. And so what we've learned is that an employee may be entitled to accommodation for a pre-existing disability that places that employee at a higher risk of serious illness from COVID-19, or that is exacerbated by the current situation created by the pandemic. And critical infrastructure workers and essential critical workers have the same accommodation rights as other employees. And that's important to note because these are often positions that require employees to be at a work site, and telework just may not be a feasible option for these employees, but they are still entitled to the same accommodation rights. The ADA does not require accommodation of employees for association with an individual that has a disability, but that does not stop an employer from considering what the employee is asking for, and the employer ultimately has a choice to whether they wish to help the employee out. If the employer ultimately does decide to help employees out, do not refer to that assistance as a reasonable accommodation. Instead, you may want to consider calling it being flexible with that particular employee, offering modification or adaptation, It's just advisable to not call it a reasonable accommodation. At this time, the EEOC has not addressed whether someone with COVID-19 is an individual with a disability for purposes under the ADA. And as previously mentioned, when you are thinking about reasonable accommodations under the ADEA, you cannot just uniformly say, because you're above X age, you now must do X, Y, and Z. You instead, as the employer, have to invite employees to engage in that dialogue. And the same is true when you are considering reasonable accommodations under the ADA. You invite employees, if they wish, to request reasonable accommodations or flexibilities to meet other needs due to the pandemic. And so again, the emphasis is on invitation. So it's not the employer requiring people, but inviting people to engage in that conversation. Employees are still required, ultimately, at the end of the day, to come to the employer and to make that request for the accommodation. Once the request is made, it's still the same as any other request. The employer must conduct the interactive process, including requesting medical documentation to determine if to determine the level of the disability and the needs for accommodation. Importantly, COVID-19 may delay the usual processing of accommodation requests. For example, getting into a doctor's office may be a little bit more challenging in these times. So employers may think about providing interim accommodations as employees are collecting the documents they need to support their leave request. And so just to sum up all that we have gone over with aging workforce and disability discrimination, in this time, it is some active steps the employer may take are reviewing their hiring practices, their ADA policies, and the handling of ADA issues. And in light of that review, updating employee handbooks and forms and job descriptions, and also training managers, supervisors, and HR personnel on the massive scope of the ADA, and place a greater emphasis on that reasonable accommodation standard, noting that employees may not use that language, but any request triggers that interactive process requiring employers to actively engage with employees to find a reasonable accommodation. And so last but certainly not least, we are turning to the Family Medical Leave Act. And so eligible employees under the Family Medical Leave Act are entitled to unpaid job protective leave of up to 12 weeks for their own serious health condition. And so a serious health condition is any illness, injury, impairment, or physical mental condition that prevents an employee from performing his or her job functions. And so it requires the employer to provide the eligible employee with up to 12 weeks of job protected leave each year. The leave does not have to be taken all, consecutively. It may be intermittent, and it is unpaid. And the employer can require, or the employee can choose to use accrued paid benefit leave, since the FMLA leave itself is unpaid. Employers must provide the same healthcare coverage and benefits during FMLA leave as they otherwise would have provided to the employee. And so with the Family Medical Leave Act, as we think about an aging workforce, employers are likely to see the increase of intermittent leave with older workers. And what that means is employers should have a rule that requires at least 30 days notice for intermittent leave when the leave is foreseeable. Require older employees to work with the employer to schedule that intermittent leave. Demand or request medical certification of the older employee's need for FMLA leave. And then in that demand, request an estimate of how often the employee will need time. and then ask for second or third opinions if the employer is still unclear or there's doubt on the employee's need for FMLA leave. And so under the FMLA, you are, as the employer, allowed to deny, or the FMLA allows you to deny only reinstatement, not the actual leave itself, to certain key employees. And the standard for this denial is very hard to meet. The FMLA states that you may deny reinstatement at the end of an FMLA leave to a highly compensated key employee if reinstatement would cause substantial and grievous economic injury to the employer's operations. And so the important point here is that although a key employee may not qualify for reinstatement, the employee is still entitled to take an FMLA leave and receive all the benefits that would otherwise be provided to them during that leave. And so in addition to invoke the exception, the statute imposes two more requirements. First, the employer must notify the employee of the organization's intent to deny reinstatement once the employer has determined it would cause a qualifying injury. And second, if the leave has already begun, once the employer makes this determination, you, as the employer, must give the employee the opportunity to return to work within a reasonable period of time once the notice is given. And just a point of record here, the FMLA defines key employees as salaried employees who are in the highest paid 10% of the employer's workforce and within 75 miles of the employer's work site. And so here we talk about the correlation between the ADA and the FMLA. And so when FMLA leave is exhausted, the employer must go into that ADA accommodation process that we previously discussed. FMLA serious health conditions can also qualify as an ADA disability. And so the employer must consider further leave after the 12 weeks of FMLA. There's no specific time limit on ADA leave, but the leave cannot be indefinite. Light duty work, meaning FMLA qualifying employees cannot be required to work light duty. The ADA does not require employers to remove essential job functions as an accommodation. But if an employer reserves light duty jobs for workers' comp purposes, it may have to offer such jobs to disabled individuals under the ADA. We've seen increased recent litigation and attention from the EEOC when the ADA and FMLA intersect. The surge in ADA charges and lawsuits by the EEOC and private claimants across all industries. And so most cases are coming from employees who were terminated after exhausting FMLA leave and are asserting EEOC charges under the ADA. Amendments to the ADA have broadened the definition of disability, and the EEOC has taken the position that once FMLA leave is exhausted, additional leave can be triggered as a reasonable accommodation under the ADA. And so what this means for employers is that it's imperative to communicate with employees and monitor their leave, requiring medical certification for health-related leaves to determine both eligibility for FMLA, ADA. And then when the FMLA leave is up, to determine if the employee is in fact eligible for further leave under the ADA, and then to ensure that the employer's reinstatement policy allows return to the same job, not just the equivalent job, if the employee would be covered by both the FMLA and the ADA. And so with that being said, I want to thank everyone for bearing with us for going over time. I'm not sure if there are any questions or if any questions were placed in the chat. Lindsay?
It looks like we had a couple questions. Ashley, maybe you can tackle this one. If an employee has no record of a disability, is having seizures at work, and is not seeking medical attention, what steps should an employer take?
I think that's a great question, and I know that at least where I'm located here in Illinois, there was a recent case where an employee was demonstrating potential signs for the need for an accommodation, and the court found that the employer having knowledge that possibly the employee may need leave was sufficient to trigger the reasonable accommodation process. So I think the answer to that might be it depends on what the employer's jurisdiction has said about them being on notice and if that's sufficient to trigger the need to engage in the interactive process.
I don't see any other additional questions here. If you do have any additional questions, please feel free to reach out to me and or Ashley. We are always happy to talk about these issues and give any advice and guidance we can. And our contact information is provided here on this last slide. So definitely feel free to reach out. Thanks everyone for participating. And, we really enjoy these. We hope that they are helpful for you. And if there is any follow-up, we are happy to respond. Hope everyone has a good day.
Thanks, everyone. Have a wonderful Wednesday.